Going to take a look at Unit 8, the Federal Judiciary. So this is going to outline a lot of the concepts that you could see on the AP test and also your exam. And so when we look at the introduction, I'm going to look at a little bit of context. The concept of judicial review is really the cornerstone here. And then how justices may look at the Constitution. And then a little bit about how federal roles have developed over time, how they've changed. We talked about party eras in the past. We've talked about how the federal government has increased power over time relative to the states. And so we see something similar with the role of the courts in here as well. So we'll go through that. And then we'll go over the structure. A lot of the structure that we have today is somewhat arbitrary. It's what Congress decided, so we'll talk about that with Article 3 and interpretations from Fed 78. We'll talk about the process of appointing a justice, and then we'll get into what the judges actually do as far as the jurisdiction when they're deciding cases. What are they actually looking at, this sort of civil versus criminal cases. We'll get into the Supreme Courts, and then we'll kind of wrap it up with a little bit of the power of the courts specifically, and then the last part, really not a whole lot to comment on, but it's more of like a cheat sheet. Good to have examples of checks and balances on the different branches here. So going to the top. Looking at the judicial nomination process, there really isn't a whole lot of media coverage. There really isn't a whole lot of interest from the public, but from a congressional standpoint, there really is a great opportunity for specifically people in the Senate to kind of make a name for themselves, credit claiming, and it's a big deal to get on the Senate Judiciary Committee because you have an opportunity to vet. Every senator on the Judiciary Committee has the opportunity to ask questions, kind of interview each of the candidate. And this is not just for the Supreme Court. This is for the circuit courts and the federal courts, the district courts at the bottom. And so when you look at this, especially because the power of the judiciary has increased, it's even more of congressional interest for that reason. And then the other thing that we see is because the policy of the United States, especially since FDR, has grown so much in its complexity that it's really important that we look at that expanded role of the judiciary as increased opportunities for federal judges to make decisions. And there's different ways and areas that they can make decisions in, so increased in the complexity. What we're really looking at with judges, what they ultimately do, federal judges, is they conduct this judicial review. They review the right, or they have the right to rule on laws and executive acts, so Congress and the executive branch, on the base of constitutionality. And so the way the courts will check the legislative and executive branches is to render decisions constitutional or unconstitutional. And so really the idea of judicial review, we see it officially join in the courts as their main role with Marbury versus Madison, but this is in 1803. And the idea of judicial review in the 1700s was pretty common, and even Hamilton discussed it. And so while it, like I said, is not in Article 3, judicial review is the main weapon used by the judiciary to check the power of the president, the executive branch, and the legislative branch. So how do you interpret the Constitution? So there's two approaches that we look at for our course and for our scope. The strict constructionist, someone who practices judicial restraint, they are going to go based on the original intent of the Founding Fathers. And it's really a lot about the wording. There may not need a whole lot of interpretation needed because you go specifically based on the words that were written. The other approach, more the activist approach, legislative approach, really defers to more of what Congress does and allows them to really do that job. The other thing, instead of legislative, the activist role, you would call this judicial activism. And this is really more of your interpretation, loose interpretation. And I think this is maybe, here we go, loose constructionist. The Constitution is a living document, would be more of this approach. Okay, so justices, they're going to rule really on constitutionality, and we're really going to focus just on the federal courts here. So development over time. Okay, so the original founders' view is the Federalist, anti-Federalist argument. How do we interpret the Constitution? So I just put this here, maybe help you later. So the idea of what justices are actually deciding when they're reviewing the action. So when they're practicing judicial review, what is their guiding principle? What the Founding Fathers originally intended, or more of an interpretation, living document type of approach? So the traditional view, at least in the 1700s, is that judges find the law and they apply the existing law. They interpret the law. And so activist judges, oftentimes when an activist judge interprets the law, sometimes their decisions can make a new policy or can make effectively a new law. So one example we look at with like election laws is oftentimes judges don't want to even touch a case dealing with election law because there's really hefty stipulations that when you make a decision with election law, you cannot make new policy, you cannot effectively change the law, and that becomes very tricky. So to say all this a different way, sometimes when judges make decisions, they alter the law, they add new laws, and so that's something that many people don't feel is the role of a judge. Now, what we do is, because in the United States the traditional view is deciding, interpreting the law, to take this like one step further and say judges practice judicial review, people would say in the 1700s, okay, well that fits our view of what judges are supposed to do. And then over time, the federal judiciary's ability to practice judicial review only gets bigger. Bigger. So some examples. Marbury versus Madison establishes judicial review officially. It's not in Article 3, but it is common practice in the 1700s, and now it becomes much more official, an official recognized role of the courts. McCulloch v. Maryland. Maryland doesn't want a national bank. Congress creates a national bank, so you have a dispute, a civil dispute. The state says they're correct, and Congress says they're correct. The federal courts step in, and they say, actually, Congress is correct. The federal government is above the state government, and therefore, Maryland, you're wrong. You're not, have to do what Congress says. And then you could take this another step further. The court's making things bigger. So Gibbons versus Ogden, Congress already has the power to regulate interstate commerce. And then with Gibbons versus Ogden, they give them more discretion, more power to do it, and really just gives Congress even more ability to regulate the states. And then the other thing here, just because it leads up to the Civil War, is the courts themselves were really moving forward and increasing their influence. But then in the Dred Scott decision, where the Supreme Court ruled that Dred Scott was not able to sue for his own freedom as a slave because he was therefore property, and property cannot sue in a court of law. And so this decision really kind of haunts the Supreme Court's credibility, maybe not the circuit and district courts, but definitely at the high level. So going past the Civil War, the slavery issue is not as much of a component. Now it's more about equal rights for these new citizens. And, that's one component. I guess I'll go kind of out of order. So the equal rights component here, there's this newly passed 14th Amendment, and it's up to the courts to interpret this 14th Amendment. And this is something we will especially get into with civil rights, civil liberties, but there's two clauses in here. Due process clause, and then also the equal protection clause. And so now the job of the courts is to decide how they're going to enforce it. Equal protection clause, the court originally said, okay, you can segregate as long as things are separate but equal. That was their original interpretation of the 14th Amendment. Now we know that changes. But just to make an example of something new for the courts to interpret, a new amendment here. The other thing from the Civil War to the 1930s that we see is, how should the economy be regulated? This is sort of your era of two Republican parties. One Republican party is the party of laissez-faire, that the federal government should not be stepping in. But the courts really eventually come in and say, yes, the economy can be regulated by both state and federal governments. So the courts during this time increase the power of state governments. The other thing that we see, so after the 1930s, going more to the present, is increased power of the federal government to regulate commerce. And so what we're really looking at here is Congress tries more and more to regulate commerce, and the courts say that is okay. That is fine for Congress to do that. This is why the U.S. v. Lopez case is such a big example, is because in general, usually the courts let Congress do their thing and don't really intervene. But U.S. v. Lopez, they do intervene and they say, sorry, Congress, that's too much. You can't do that. The other thing that the court moves more towards is personal liberties and different freedoms. And so kind of an irony here is Alexander Hamilton claimed that if you increase the power of the courts, they will take away your rights. But really, since the 1960s, the courts, in their increased capacity, are actually fighting to defend rights. So kind of opposite impact here. So as far as an argument essay, maybe we should put that in. Okay, so if you're shaping this in an argument essay, Hamilton argued in Fed 78 that increasing the potency of the courts would ensure that rights of Americans would be taken away. So you could counter. You could say, however, counter to Hamilton, the courts, since the Warren Court, okay, so like 1950s and 1960s, worked to utilize their increased influence over federal policy to ensure equal protection under the law. And this is specifically the 14th Amendment. Good stuff. Okay. So yeah, so for the few people that actually do watch this video, I think this could be very helpful. Okay. Haha. Cool. All right, moving right along. The other thing we see is, really, since the 1960s and the 70s, we go back and then 1980s, more to today, and especially now, since we have a more conservative split on the Supreme Court, it is the revival of state sovereignty. So think of the Supreme Court as a pendulum. Since the founding of our nation, more big power, big, more liberal, activism, and then since the 1980s, we do see a little bit of a shift of the pendulum going in the other direction. So we'll see. We'll see how it goes. Now looking at the structure, really I think if you understand the different tiers and then have an idea at each level. So under Article 3, the Constitution allows for Congress to create inferior courts and stipulates that there must be a Supreme Court. However, Congress wants to make these inferior courts is totally up to them. And we've decided on 91 district courts, 12 circuit courts of appeals, and then the Supreme Court at the top that they have to have. So the other thing in Article 3 is it says that judges need to serve during good behavior. So as long as they're not breaking the law, so for example, taking bribes for rendering decisions, they will serve a life term. But understand that judges can be impeached, can absolutely be impeached and removed from the bench. Okay, so how do we structure our court systems? At the very bottom level, you have the district courts. These are the only federal courts that have juries. They're going to have original jurisdiction, so they're going to be the first time that case is heard. Could be a criminal case, could be a civil case meaning a dispute between two parties. And they're also going to hear testimony. Right, so if you want to think of which of these is most like what you see like in Law and Order and court shows, it would be the district courts. One final thing is the district courts have to take a federal case. They cannot decide to say no. So what if you don't like what the district court says? Well, you can appeal. So you can go to the 12 circuit courts of appeal, no juries. You're going to have a judge or justices, and they're going to have what's called appellate jurisdiction. So they're not hearing the case for the first time. They're actually looking for any technicalities. Were there any things in the juries and the testimony in the case that was heard? Did anything go wrong? Did they handle this incorrectly? And there's no testimony that's given. The courts of appeals can turn you down. They can decide, no, we're not going to hear your case. Let's say they do hear a case and they render a decision and you don't like what the appeals court says, you can appeal again to the Supreme Court. No juries, again, appellate jurisdiction, no testimony. They're going to see the Supreme Court, did they follow it correctly in the 12 circuit courts of appeals? And again, just like the appeals court, Supreme Court does not have to take the case. In fact, Supreme Court really only takes about 1% of all cases that are requested of them. Okay. So what about the judges? So when you go into selecting judges, one thing that we talked about with like the 40 more years Reagan cartoon is that President presidents want to choose someone that will carry on their legacy. And while we talk about judges and as like independent, and really the judiciary is an independent branch of government that transcends politics, Supreme Court is insulated. It is isolated from the public. And while all those things are true, judges still are selected by a president, partisan, and confirmed by a Congress, partisan. So that definitely plays a role. Now, how does it work? The process is, and maybe this will help too. So the president will appoint all federal judges, district, it'll also be appeals and Supreme Court. The Senate Judiciary Committee, so specific senators on a committee will vet, which means they'll interview, ask questions, see if the person is qualified, and then the Senate will vote. And if 51% of the Senate votes, they will confirm the justice, and then that judge will serve a life term. They can be impeached, they can be removed, but as a president, this is a very important role, is to appoint all these judges for the Supreme Court. Also the appeals court, and the district courts. What am I thinking? Yep, all these levels. Okay. Then we move through the jurisdiction. What are they actually deciding? What do they have the authority over? And so federal cases that are listed in Article 3, so and some that are stipulated in the 11th Amendment. So if we look in the Constitution, what do the inferior courts look at? Well, they have jurisdiction over things like criminal federal laws that are committed. Anytime there's like issues within the EPA or other agencies, those can be heard in a federal court, wrongdoing or malpractice. Also cases of bankruptcy, and then any issue between two states, right? This would be a civil case, a dispute between two parties, whether it's two human beings, two corporations, a corporation and the government, two governments, state government, federal government, two state governments, something like that. That's most of what the courts hear, although they will hear criminal cases. So like if you break like a international or like maritime law issue, that'll also be heard in a federal court. But these are the two types. Civil, much more common. I mentioned this in the past, but just, always good to be able to differentiate. You need to know the difference between original jurisdiction and appellate jurisdiction. You should also be able to tell me which courts have original jurisdiction and which courts have appellate jurisdiction. So let's just go through. District courts always have original jurisdiction. Appellate jurisdiction is the second or third time it is heard. So you would say the circuit courts of appeals have appellate jurisdiction. The Supreme Court, appellate jurisdiction, although the Supreme Court could technically have both. In the case of U.S. v. Nixon, we're not going to wait for it to go through the lower courts. The U.S. needs to sue Nixon to make sure that he follows the congressional subpoena. We're not going to wait. Bush v. Gore, we don't have enough time. We need to go straight to the Supreme Court. That's fine. But then, most of the time the Supreme Court will do appellate jurisdiction. And I know that's a lot of, going on, but it is up here as well. So looking at actually getting to the courts. So understand, all cases have to be heard by the federal district courts, but after that, it's totally the discretion of the court whether or not they would like to accept the case. So most things are handled outside of court. Most things are handled in state courts, and even more of those things don't even get to the full courtroom. And so when we talk about courts of appeals, the court is going to reject 95% of applications for certiorari. Certiorari means that you're going to hear the case. So to say it a different way, people and groups will appeal their decision. They don't like what the court said, so they're going to petition for the court to hear their case. Basically what they're asking for is the court to issue a writ of certiorari, an agreement that they will hear the case, and then the case will be put on their agenda, what we call a docket. So for the Supreme Court, we practice what's called the rule of four. Writ of cert is granted if 4 of the 9 justices want to hear the case. They're not deciding the case, they're deciding if they want to hear it, and you don't need a majority. Now, one thing that deters appeals from happening, so if you're thinking, well, if you don't like your decision, of course you should appeal. Well, it's very expensive. And oftentimes you'll need interest groups to step in and kind of help pay for those types of things, and that will happen. We'll talk a little bit about the NAACP in this as well. And then, let's see. So if we move on, like class action lawsuits, this is not an emphasis on your test, mostly because we've talked about class action lawsuits where they're brought on behalf of a bunch of people and there is financial gain to be had. Maybe one thing to point is that there hasn't you need to notify all the members since 1974. This can be very difficult to accomplish, and so the Congress is trying to limit the number of class action lawsuits, but don't really need to know that for this unit. It's about the Supreme Court. With the Supreme Court, they usually don't have original jurisdiction, as I mentioned, but they could. Most often do not. Now, how do you get to the Supreme Court? Well, oftentimes you just apply. You petition for a writ of cert, and oftentimes they will decline your writ of cert. So most cases start in the district courts and are done. No precedent sets, no overarching concept for the future. And I really think that, like I said before, most cases are heard, even in the state courts and don't even make it to federal courts or don't even make it to the full courtroom itself, are settled outside of courts. Supreme Court gets to choose their own agenda. As I mentioned before, you need that rule of 4, and then they will issue a writ of cert. And usually what the Constitution is, or what the Supreme Court is dealing with is a conflict between circuit courts. So let's say the Ninth Circuit decides one thing and then a state circuit decides something else. They want to make sure to unify that, kind of iron out the decision. And then oftentimes what will happen too is something will come from the state courts. So talk about like voter fraud in the Supreme Court. Pennsylvania Supreme Court ruled one thing, and then it was petitioned to the Supreme Court to hear it. The Supreme Court decided not to hear it. But again, that is within their discretion. So what does it look like when the Supreme Court hears a case? Well, after they accept the case, they're going to hear oral arguments. And the oral arguments basically is going to be like in the case of Brown v. Board of Education. Thurgood Marshall, a lawyer hired by the NAACP, is going to represent Brown and is fighting against this individual who asked to attend a school, Ruby Bridges, which is much further away than her neighborhood school. And so Thurgood Marshall is going to stand up in front of the Supreme Court justices, and they're going to hear his arguments about Brown. And then the Topeka, Kansas Board of Education is going to step in, and they're going to offer their oral arguments. So both sides in front of the Supreme Court justices. No media is allowed, and only lawyers attached to the case are allowed. It's very, very isolated. Now, sometimes the United States is involved. U.S. v. Nixon, U.S. v. Lopez. And in that case, there's a trial attorney that represents the United States in the courtroom. So anytime it's a United States versus what we're looking at is the Solicitor General in the Justice Department will be the person to represent that. Now, the other thing that we could see, and I should probably put this one as a indent too, is that amicus curiae briefs can be used by interest groups. So if you take the case of Brown v. Board of Education, the NAACP would have worked with a legal team to create an amicus curiae brief to give to Thurgood Marshall to better argue the case, because it is very much in the interest of the NAACP to get this case heard by the Supreme Court and eventually have school segregation overturned. When justices are hearing the cases, it's about the constitutionality, but because there has been so much written about the different cases, because there have been 200 years of litigation to look through, there are many things, including law journals, that the justices will take into consideration. And this also creates a more diverse amicus curiae brief, and interest groups will try and step in too. Interest groups can be influential in the writing of law journals and things like that, trying to further their agenda. So the procedural needs, or the procedural part here. So first is accepted. Rule of 4, we're going to hear the case. Excellent. Grant a writ of cert goes on the agenda. Oral arguments are heard. And then at that point, there will be specific oral arguments from the justices. And so you'll have the Chief Justice speak first. Everyone gets a chance to speak. Everyone will vote. The Chief Justice will vote last. And then you have the opinions written. So let's say it's a 5-4 decision, which is the most common. The majority is the 5. Okay, and they're going to decide, this is why we decided this, and this is our majority. Now, there also may be concurring decisions where they agree with the five, but they will provide a different argument for why they agree. So you could say the majority's main argument is utilizing the Commerce Clause, and the concurring opinions say, yeah, I guess Commerce Clause, but really we think this decision is correct because of using the Necessary and Proper Clause. So a different way of getting there, but agrees with the majority. And then we don't call it a minority decision, we call it a dissenting opinion. And the dissent is, in this case, is the four. And the four disagree with the majority, and this is their opportunity to put in writing why they disagree with the decision. Sometimes, because things change, eventually the dissenting opinion can become the majority decision of the court. Now, what power do the courts have? So, by interpretation, a lot of policies will be made because of the interpretation of the court. So, integrating schools. So, the idea that you cannot segregate schools is something that the court decided and is followed and enforced. Being given a lawyer, if you cannot afford one, this was not always the case in state charges. It was usually only federal charges. Now it's any charge. And so the court can make this a decision, and then this is the wrong rights here, but read your rights when you're arrested, so your Miranda rights. This is also something that was created based on a court interpretation. The other thing that we could see is they can make a law bigger. For example, like when you talk about a lot of New Deal legislation, a lot of it was upheld by the court, and really Congress sometimes would even go back, or President Roosevelt would issue an executive order that even increased the value or the power of that executive order because the courts allowed it to exist. And then the other thing is the courts will step in to fix problems. So, for example, the idea of deciding what is separation of church and state, or how can we tell? Before the 1970s, we didn't really have a specific test. Now, with the court case Lemon v. Kurtzman, not something you need to know for your test, but just it creates a Lemon test, which is a specific test to see if something is breaking a separation of church and state. So these are just some general, what do the courts do? What is the role of the court? So maybe on an argument essay to discuss what are the roles, hungry, okay, of the courts. Okay, cool. Excellent. So what do we look at the power here? So measures of the power. So in our country, we have had more than 120 laws of Congress been ruled unconstitutional. Now, that means the vast majority of them have been constitutional or have not been checked. But the idea is that the courts do render power. The ability to render more than 100 bills unconstitutional and have it be respected by the other branches of government is a big deal. However, sometimes cases are overturned. It could, I guess, technically hurt the credibility of the court to overturn a precedent, but things do change. If something is overturned, you are going against stare decisis. You are going against what is normally the precedent and let things stay the way they are. Stare decisis is kind of a status quo type of interpretation. So Brown v. Board overturned Plessy v. Ferguson. Plessy v. Ferguson in the 1800s, late 1800s, said that you can segregate as long as things were separate but equal. And then Brown v. Board in the 1950s said, no, that's actually incorrect. Incorrect interpretation of the 14th Amendment. The other thing, too, that we see is most often, and you want to talk about a major role of the courts, is oftentimes the courts will let Congress fix things. If you want to talk about original interpretation, so this is something you could also see on an essay, is the original intention of the Founding Fathers is that Congress would do the heavy lifting, and this would kind of be like the impotency argument of Hamilton and Fed 78, and then Madison talking about how much Congress should be the superior branch. You could talk like Fed 51 for that one. Okay. Now, as far as like legislation and the courts, sometimes the language that is in the law is vague, and so the courts can interpret that. And that's something, if Congress doesn't like how the court interprets it, they can also rewrite a law, which does happen too. Right. So this last part, nothing really to go over, but just as a cheat sheet, it is good to have a couple of examples of checks of how the judiciary checks other branches and vice versa. And so I tried to put a couple of examples in here, but really this is supposed to serve as a cheat sheet for you. Okay. If you have any questions about the federal judiciary, just let me know. And I tried to put a couple of things in color and then underline things that can help you guys for a test.